just to make it clear, as a federal public defender, you were assigned to represent Guantanamo detainees. Is that right?
That is correct, Senator.
And then while at Morrison and Forster, you also did pro bono work for Guantanamo detainees. Were you assigned to do that work as well?
So there was one detainee who I had represented as a federal public defender who was brought into my firm's practice unbeknownst to me. And when I arrived at the firm, the attorneys who were working on that case recognized that I had previously been a lawyer who had represented this particular detainee and asked if I would help with his habeas petition at that stage.
I think you clarified that earlier today. And you served as counsel of record on amicus briefs related to detention. I think that was brought out today.
Yes.
Were you working on behalf of detainees at that point, or were you working on behalf of other groups or individuals?
I was working on behalf of other groups or individuals in with
Were
respect.
they retired judges?
Yes, there were 3 briefs in total, 2 different cases, and one of the briefs that I filed was on behalf of 20 retired federal judges, including one who was a partner at my firm at the time, and who wanted to make a particular argument to the court concerning the detention process.
And these were judges that were nominated by various presidents, so it must have been a diverse group, and they asked you to do the brief.
And they did, yes.
So as part of your work at the law firm, a responsibility of your employment, you were assigned to work with this diverse group of retired judges and to represent conservative or libertarian organizations such as the Cato Institute and the Rutherford Institute to advocate their views.
Yes, the other 2 briefs that I filed were at the cert stage and then at the merit stage of a case that was eventually mooted. But my clients in those cases were a diverse group of organizations, including the Cato Institute, the Rutherford Institute, and the Constitution Project.
Members of this committee know full well that lawyers are, we have to follow the codes of professional conduct, which says that we have to zealously represent our clients, and that's what you are doing with regard to the detainees. And I would just want to note that some of the very senators who are openly questioning you for representing defendants or detainees have in the past made the argument that judicial nominees should not be opposed for the arguments they make in the course of representing clients. I'm going to quote one of my colleagues. I've been a military lawyer for almost 30 years. I represented people as a defense attorney in the military that were charged with some pretty horrific acts, and I gave them my all. The system of justice that we're so proud of in America requires the unpopular to have an adequate and an advocate. And every time a defense lawyer fights to make the government do their job, that defense lawyer has made us all safer. Do you agree with that?
I do, Senator.
In 2012, prominent conservative lawyers signed a letter defending attorneys who have represented Guantanamo detainees. In part, the letter said, quote, "The American tradition of zealous representation of unpopular clients is at least as old as John Adams's representation of the British soldiers charged in the Boston Massacre. Good defense counsel is key to ensuring that military commissions, federal juries, and federal judges have access to the best arguments and most rigorous factual presentation before making crucial decisions that affect both national security and paramount liberty interests," end quote. So the quote that I read isn't the first time that my colleagues on the other side of the aisle have tried to say that your representation and your work as a public defender somehow, I don't know, disqualifies you or makes you leaning one way or the other. So you've made it very clear that that is not what you are about.